And our next panel, coming up on deck, and this is our final panel, is the Honourable Madam Justice Michelle Fuerst and Frank Addario. They have a lot of things in common, but one of the things that is indicated in your paper that you're probably also aware of is both are past presidents of the Criminal Lawyers Association of Ontario. So in order to keep with our timing, I'll leave it to them to talk about 24-1.
Thank you. I just want to follow up on something that I was thinking about as I was listening to the last panelists. Just if you need extra motivation about why to take that extra step after the case is over and you've got charges withdrawn, there's a line of cases in the United States that upholds good faith findings on search warrants for police forces that act on incorrect information that's in their computer about the criminality of defendants that should have been corrected. And defense counsel had not written to the local agency, obviously, and asked them to clear that information once charges were withdrawn. And one of those cases ended up in the Supreme Court last year with a predictable result. And the court said the police made a good faith effort to rely on the computer database. It showed criminality. They were entitled to rely on that. There was no breach of the Fourth Amendment. So there's an additional reason why taking that step would enhance your client's civil liberties, one of which would be privacy rights. As I try to emphasize in the paper that you have, Section 24.1 is one of those charter articles that gives counsel a chance to get creative. And what becomes clear when you look at the cases and the template created by the Supreme Court is that you can ask a trial judge to do almost anything known to the world of remedies. And there is no equivalent example, as I read the cases, in the common law or in any statute. Section 24.1 is as broad a remedy as can be found. And so long as the remedy that you seek complies with the basic template and rules, the court can grant it. The best illustrations of the flexibility of Section 24.1 are the cases where the courts force the government or government actors to take positive action. We all recall those cases from law school. Do you remember being told that specific action can't be ordered by the courts? But in fact, Section 24.1, the jurisprudence is replete with examples of specific action being ordered against people. Some common orders are disclosure orders, state-funded counsel, row bottom orders, and ordering the minister to obtain assurances in extradition cases, such as we won't kill this guy if he's returned to our country. But we don't think about fact-creative, restless defense counsel coming in and asking defense trial judges to do other things. For example, David Tanovich has written an article suggesting using Section 24.1 to remedy Section 9 breaches by requiring police in a particular jurisdiction to collect stop data so that proof of over-detention of youth and minorities would be made easier. Another example, early Supreme Court jurisprudence prior to Askov, the early cases prior to Askov, in the good old days before the stay of proceedings took over as the only remedy available, was filled with judges debating the merits of ordering individual courts to bring people to trial more quickly. Positive action orders. And all of the Supreme Court judges at various times contemplated the legitimacy of those orders under 24.1. Likewise, there is overwhelming evidence that mentally disordered people do poorly in jails. It's been judicially noted by courts as high as the Ontario Court of Appeal. And yet, routinely, judges say that people can sit in jail before they get a hospital order Some judges, not all judges, but some judges use Section 24(1) to move that defendant's body immediately under pain of a stay of proceedings or costs to a hospital. Those judges who don't could be educated by defense counsel. So those are just examples of how 24(1) can be used in a creative way to remedy unfairness. In this panel, we are going to go through the trial process and explain when you could consider raising those remedies, why you should be raising them, and how to argue them most effectively. We have the benefit of having an experienced trial judge here to explain the latter point. I do want to take a moment to ask Justice Fuerst about that, because a great deal of your success is going to depend on how you pitch that remedy and on your voir dire with your trial judge. So I would like to turn first to Section 24(1) as a preventive remedy, and perhaps just ask Justice Fuerst just to, if we could just contemplate the exclusion of evidence not following a breach, not under 24(2), and the circumstances in which a judge could be asked to exclude evidence not under 24(2).
All right, so we have to go back and just remember that under 24(2), the evidence has to be obtained in a manner that infringed or denied any rights or freedoms guaranteed by the Charter. So what that means under 24(2) is that you have to have a Charter violation that occurred in the course of obtaining the evidence. But sometimes the concern that you have isn't that your client's rights were breached when the evidence was being gathered. Your concern is, how is the evidence going to be used at the trial? And the potential use of that evidence is going to, in your view, render the trial unfair. That's when you need to turn to Section 24(1) as a potential route to exclusion of the evidence, because the argument is that the use of the evidence is going to breach the accused Section 7 and/or Section 11D right to a fair trial. So how would you go about trying to use Section 24(1) in that circumstance to get the evidence excluded? There are two cases from the Supreme Court of Canada that really ground this potential route to evidentiary exclusion. The first is Regina and Harar, and all of the cases I mentioned this morning are in Frank's paper, so I'm not going to use cites. But Harar was a Supreme Court of Canada case. The issue was whether evidence that was obtained by foreign police officers in a foreign country in a way that would have breached the Charter had it been done in Canada was admissible at trial in Canada when the accused ultimately was charged with a related offense in Canada. And in that case, the Americans, police marshals, had investigated the accused boyfriend, had therefore taken a statement from the accused. At that point, she wasn't the accused, she was just the girlfriend. And initially, their interest seemed to be in immigration matters that had to do with her and the boyfriend. But the questioning got around ultimately to things about how she may have been involved in the boyfriend's escape from custody in Canada. The police officers who questioned her in the States complied with Miranda, but they did not, of course, comply with Section 10B of the Charter. What happens next? She goes back to Canada. She gets charged in Canada with assisting the boyfriend to escape lawful custody in Canada. So she's now an accused in Canada. The Crown at trial wanted to put in the statement that she had given to the U.S. Marshals in the United States. Her counsel objected. The trial judge held that her Section 10B rights had been violated in the U.S. and excluded the statement under 24(2). The case wound its way to the Supreme Court of Canada. The SCC said, look, Section 10B had no application to American police officers or marshals who are acting in the United States, clearly on behalf of American authorities, not on behalf of Canadian authorities, and therefore the trial judge was wrong to exclude the evidence under Section 24(2). But having said that, the court recognized that there will be circumstances where to admit evidence obtained in another country in such a way that, had it been done in Canada, would violate the Charter, could render a subsequent trial unfair and violate 11D or 7 of the Charter here in Canada. The majority said in these kinds of cases, the trial judge could resort to his or her common law power to exclude evidence because the admission of it would render the trial unfair. What's interesting about Harar is the minority decision, which was authored by Justice McLaughlin, as she then was, because she said, yes, it's true, trial judges do have that common law power, but in addition, we now have the Charter and we have Section 24(1) of the Charter. And she said, in addition to any common law power to exclude because of the danger of rendering a trial unfair, you can make an argument that evidence that was not obtained in breach of the Charter, but if it is used at a trial will undermine the fairness of that trial, should be excluded under 24(1). So that's where the thought about using 24(1) first comes to the fore. So if Justice McLaughlin's minority decision in Harar unlocked the 24(1) door, the next case in the Supreme Court of Canada appears to have opened the door wide, and that next case is White. And you'll remember that in the White case, the female accused had been involved in a motor vehicle accident. She was required under the provincial motor vehicle legislation to provide a statement to the police. She did so not just once, but 3 times. Was ultimately charged under the criminal code with leaving the scene of an accident, and the Crown at trial wanted to put into evidence all 3 of her statements to the police, which she gave under the provincial statute. The trial judge found that to admit those statements, because they were given under compulsion of the provincial legislation, would violate Section 7 of the Charter. And the trial judge used 24(1) to exclude the statements at trial. The case again wound its way to the Supreme Court of Canada. The Supreme Court of Canada agreed, yes, the statements were compelled under the provincial motor vehicle statute, said they could not therefore be used in subsequent criminal proceedings. Why? Because to do so would violate the protection against self-incrimination provided by Section 7. Justice Iacobucci, who wrote the majority decision for the Supreme Court of Canada, looked back at Harar. He said, I agree with the majority in Harar that, you know, it may not really be necessary for the trial judge to resort to Section 24(1) to exclude this evidence, because the judge does have the common law power to exclude evidence, the admission of which would render the trial unfair. But having said that, he went on and said, I've also looked at the minority decision in Harar, and I agree with Justice McLaughlin that Section 24(1) can be used to exclude this kind of evidence. And on behalf of the majority of the court, he concluded that the trial judge had done the right thing in that case when the trial judge relied on Section 24(1) to exclude the evidence, and that trial judges are entitled to do that. So we move from Harar, a minority decision, all the way to White, where the majority now signs on to the use of Section 24(1) to exclude evidence. What isn't so clear, at least to me, is that when should you as defense counsel then move under 24(1) of the Charter to exclude evidence, as opposed to just asking the trial judge, use your common law power to do it. And the Supreme Court of Canada, respectfully, it seems to me, has not been all that helpful on this point, because they really haven't clarified or given an answer to that question. And what I think is important for you as defense counsel to bear in mind is that if you move under 24(1), you have a double whammied onus. You've got, first of all, the onus to prove the Charter unfairness, usually under Section 7, and you've got then an onus to establish that the proper remedy is exclusion of the evidence under 24(1). And in both instances, you've got to prove this on a balance of probability. Whereas, if you go under the common law, it's not so clear that you've got an onus of proof on a balance of probabilities at all. What you're doing under the common law is asking a trial judge to exercise his or her discretion to exclude evidence, because otherwise the trial is going to be unfair, and the trial judge has an obligation to ensure trial fairness. So we don't normally refer to a standard of proof when we're talking about judges doing something to ensure the fairness of a trial under the common law. So I just throw that out there as something I think you just need to think about a little bit. And in addition, more recently, the Bjelland decision, I may be mispronouncing it, which was a case of late disclosure by the Crown, said something about Section 24(1) that may be a little bit troubling if you're trying to use it to exclude evidence, because in that instance, dealing with exclusion of evidence because of late disclosure by the Crown, the Supreme Court of Canada said, the majority said, the exclusion of evidence under Section 24(1) will only be available in those cases where a less intrusive remedy cannot be fashioned to safeguard the fairness of the trial process and the integrity of the justice system. And again, it's not entirely clear to me that when the majority said that, they were restricting themselves to the pure instance of exclusion of evidence because of late disclosure by the Crown, as opposed to using 24(1) to exclude evidence more generally. So, to summarize all of this, it seems to me that yes, Section 24(1) does provide a remedy by way of exclusion of evidence. It might be new and different to you to try to use Section 24(1) to achieve this. Just because it might be new and different doesn't necessarily mean you should launch on a Pavlovian-esque response. I see a trial fairness issue, therefore I'm going to raise Section 24(1), because you really do need to think it through. And if you can go under the common law, ask the judge to exercise his or her common law jurisdiction to exclude, maybe you're further ahead. I don't know, Frank.
Okay, so I agree with all of those observations, subject to this. If you lose, if you fail to persuade your trial judge, okay, plug your ears here, trial judge, and you end up having to appeal it, plug your ears, trial judge, because the trial judge is convicted, you likely are going to have more luck persuading the Court of Appeal to reverse a ruling under 24(1) as a question of law, erroneous decision on a question of law, than you are exercise of discretion to preserve the fairness of trial, right? So all those charter cases that we see going up are always question of law. Should the judge have exercised it? So that's the only reason I might consider throwing it in. I agree with everything that's just been said about the power actually currently being broader at common law around the exclusion of evidence that has not been obtained in a manner in violation of a charter right, but the collection of the evidence nevertheless implicates how the fairness of the trial would operate. And so that then takes us, I think, to the topic of prohibitions. And when you want to ask the judge to, your trial judge, to give you a preventive remedy, and that's your solution if the Crown or the police are about to do something that you perceive to be unfair, that potentially could violate Section 7 or a specific Section 11 right. There's a myriad number of scenarios that could arise. For example, the Crown is undertaken not to call a witness, and then later on determines that it's going to call a witness. Now, the judge may say, look, I have no power to prevent that at common law. I can't control how the Crown calls its case. And you might say, in that case, I'm going to have to ask you to resort to the charter because you need to preserve a fair trial under Section 7. And here's the evidence that would authorize you to do that. Here is what I can show on a voir dire. Another scenario arose in the JSR case, which for those who are not from Toronto was the Jane Kriba shooting on Yonge Street. And the allegation by the defense was that they had been prepared to make an admission. They'd made the admission about potentially prejudicial evidence. The Crown was insisting on calling it nevertheless. And the defense position was the Crown is just attempting to get prejudicial information in front of the jury for no forensic purpose, unrelated to proof of its case. And they asked Justice Nordheimer to use his discretion to exclude it. And he did comment on the impropriety of that from his perspective. and the and discuss the common law powers to exclude. But again, it's another scenario where if your judge feels that he or she is butting up against the limits of their common law power to control Crown action, you may wish to ask the judge to contemplate whether or not Section 7 and 11D, as they're described, describe a wider power and allow you to get a remedy. In conclusion on these pretrial remedies and preventive remedies, what I think my message would be to defense counsel is think very clearly about what the potential violation of the fair trial right is before you ask for a remedy for it. Think very carefully about whether or not there's a remedy available at common law, and just look down the chessboard a couple of moves and think about what happens if you lose and where you want to be afterwards with the result. And if you lose, and if you lose the trial, where do you want to be afterwards with the ruling from the trial judge? Remember that if you are, in fact, going to litigate it as a 24-1 hearing, you need to give your judge an evidentiary basis to make the finding of the breach or the potential breach before she can exercise the power. The days of seat of the pants issuing of orders is long behind us, and people don't hesitate to notify their superiors and ask them to file a notice of appeal on the Crown side if a judge has done that. So you need to help your judge out. You can't ask your judge to do that. You need to create a proper record. Okay, and that takes us then to something I mentioned at the outset, which is less drastic remedies to a stay of proceedings. This is or should be a favorite area for defense counsel because, as you know, many judges recoil at the idea of granting a stay of proceedings and depriving the community of a trial on the merits, but many judges are attracted to lesser remedies. And I just want to ask Justice Fuerst about one of them, and it's costs. It's familiar. It's been around for 15 or 20 years now. How's that work, and when do you get it?
All right, let me tell you about two cases. One is one you're probably aware of because it's been around for a while. Again, a Supreme Court of Canada case, Regina 974649 Ontario Inc., which was a case that dealt with whether a provincial offences court could award costs against the Crown as a remedy under Section 24(1) for untimely disclosure. And the court said yes. Costs awards are connected to the court's control of its trial process. They have a compensatory element, but in the criminal and regulatory law context, they are intended as a means of disciplining and discouraging flagrant and unjustified conduct. And what the court said was that costs awards against the Crown in criminal and regulatory matters are restricted to cases where there is, at a minimum, circumstances of a marked and unacceptable departure from the reasonable standards expected of the prosecution. Now, what does that mean in practice? I think one of the reasons why we don't see a lot of cases in which costs are awarded against the Crown is because that is a relatively high standard. I can say in 11 years on the bench, I've been asked to order costs against the Crown in only one instance, and I did order costs against the Crown in that instance because there was an evidentiary foundation, unfortunately, for conduct that fell below that standard that the Supreme Court of Canada articulated. More recently, the Ontario Court of Appeal has looked in a case called Regina at Tiffin, again at the issue of costs awards in the criminal context. In that case, the trial judge had quashed search warrants in a fraud and tax evasion case and also excluded the evidence that had been seized. He found that the Canada Revenue Agency officials who had been involved in the background investigation had engaged in what he viewed as serious misconduct, and as a result, he ordered the Crown to pay costs to the accused, even though he said he found no fault with the Crown, with the prosecution or prosecutors. So the case went on appeal to the Ontario Court of Appeal, where the majority said, yes, there was a Section 8 breach, but the seized materials should not have been excluded. And on the issue of costs, said costs should not have been awarded at all. And in the context of a costs order against the Crown, reiterated the standard that I just told you had been set by the Supreme Court of Canada. Perhaps more importantly for your purposes, the majority said that costs should not be routinely ordered in favor of accused persons whose charter rights have been violated. So in other words, what the court is saying to all of us is, look, just because the trial judge finds there was a breach of a charter right doesn't mean that automatically a costs award should follow. The court also looked at cases where the misconduct involved was not Crown misconduct, which really was the scenario in Tiffin. In other words, the conduct wasn't that of the prosecutors. The conduct was that of the investigators in the background, and said that the jurisdiction to award costs against the Crown under Section 24(1 in those instances where the misconduct isn't that of the prosecutors requires something rare or unique that must at least result in something akin to an extreme hardship on the accused, and called that sort of costs award an extraordinary remedy. So it's going to be, I suggest to you, a rare case in which you've got misconduct by, for example, police officers, and therefore an order of costs being made against the prosecutors in the case who have had no involvement in that misconduct. And in Tiffin, the majority said, look, there was nothing unusual about the fact that the charter application succeeded. There was no misconduct that was attributable to the prosecutors involved, and there was absolutely no indication that those prosecutors had contributed to the police misconduct. For example, had said to the police officers, oh yeah, go ahead and violate the accused's rights by executing search warrants on a basis that was unjustified. So I think you want in these scenarios, Frank, to draw a careful distinction when you're seeking costs against the Crown. Is it because of prosecutorial misconduct, or is it because of misconduct by somebody else, like police officers or investigators in the background? Because there are two different standards, and arguably, as you know, police officers are third parties to the proceedings. And for trial judges to make cost orders against third parties is going to be a rare happenstance, because as a general rule, we don't have the power to make orders against individuals or entities who are non-parties to the proceedings. So just watch out for that.
So how does the defendant get a remedy then? He's got the police officers or the investigators who've created this completely unwarranted, just for hypothetical purposes, completely unwarranted investigation against him. They've put him and his family through months of turmoil. They've maybe interrupted his business, and the prosecutor takes it, and on its face it looks like a legitimate investigation, looks like a legitimate search warrant. He litigates it. During the course of it, he discovers it's empty. Judge entitled to do anything at that point to help the guy out, or send him off to civil court?
I think you have to send them off to civil court, unless you can show either some sort of link between the police misconduct and the Crown. For example, by way of giving advice that was perhaps reckless or negligent, so that may be one scenario. Or you can meet that high standard that the court talks about in Tiffin, where an order can be made against the Crown even though it's not the Crown's misconduct. If you're not in one of those two scenarios, then yes, I think for the purposes of the accused, he's off to civil court.
Would it be fair to say that the Court of Appeal and the Supreme Court have really tried to tamp down costs in criminal cases, that they've really tried to limit it to highly unusual circumstances and shuffle that remedy off to the civil courts?
Absolutely. It's great to say this is an option under 24(1), but if you go and look for cases where costs have been awarded, I think they're relatively few and far between. In the civil litigation sphere, of course, it's accepted that, costs follow the cause, so to speak, and indeed we see in the course of motions before civil cases ever get to trial, people asking for unbelievable amounts of, $50,000 and $60,000 by way of cost awards for a motion. It's a completely different arena, though.
It's what defense counsel get for a first-degree murder trial.
Well, it is, and those of us who have done criminal work, I think, look much more skeptically at some of these requests than those who come from the civil bar, but that's another topic.
Okay, well, I did mention in the paper the Ward case, and sometimes those civil cases are worth reading, not for reasons of envy, but for reasons of if you are fairly certain that you're going to be sending it off to Sean Dewart or someone like him, or you're fairly certain that you are creating a template for some form of remedy for your client, you'll want to know what judges in that world are looking at, what they consider relevant to whether or not a constitutional violation took place that should be remedied. There's some eye-opening remarks in the Ward case by Chief Justice McLaughlin about how constitutional violations get remedied in the civil world, and I'm pretty sure I included a reference to that in the paper. Another remedy short of a stay of proceedings, and one of my personal favorites, is a judicial instruction. And what I like about that topic is that you can get a reasonable doubt in a clean way. And think of the cases where police misconduct or police negligence has prevented you as defense counsel from offering up a really good piece of exculpatory evidence, either through failure to preserve something that you can show was or was likely to be exculpatory, or failure to get a witness there, or failure to locate a witness, or fouling the memory of a witness, or destroying the quality of evidence, for example, eyewitness evidence that might exclude your client. So think of all of those examples and think of the missing evidence cases, think about how they work when juries, so the Bureau case is an example of how they work when there's a jury, but think about how you want to transform that into reasonable doubt under with a section 24(1) instruction when there's no jury. How you can persuade your judge that she really can't be sure of your client's guilt because of police conduct, and that how it is proper to reformulate an approach to WD taking into account the failure to preserve evidence, and that the judge can do that with a combination of findings of fact and an understanding of a positive police duty to preserve evidence, whether or not it is incriminating or exculpatory. So this is not to ask your judge to do something exotic or to go out on a limb. It's to ask your judge just to apply principles of reasonable doubt in an understanding of the lost evidence cases that expect that the police will approach investigations with professionalism, that they won't foul an eyewitness identification case just because they think that they've now got your client, they've got Johnny in custody, so they're going to start putting pictures of him out there in the newspaper, which prevents you from ever excluding him as a person who was at the scene with all other people who read that paper, or any other manner of things that they might do that prevent you from later establishing exculpatory evidence. Less than a stay of proceedings, but more than a poke in the eye with a sharp stick. After conviction, 24(1) remedies, sentence reduction.
Well, you've probably all read Nasagoluak from the Supreme Court of Canada, which Frank refers to in the paper, that dealt directly with this issue. Can you use 24(1) to ask a judge to reduce the sentence beyond the minimum? And I think what's interesting about this case is that the Supreme Court of Canada once again says, yes, you can do it, but didn't do it in that particular case. And the factual scenario in that case was arguably extreme enough that I'm not quite sure just how much worse it has to be before you would actually get a court to do this. But having said that, let's just back up, because the court does lay out 3 different scenarios that are useful to bear in mind when you're making sentencing submissions. Scenario number 1, the court said, is, look, you've got evidence of state misconduct. It doesn't relate to the circumstances of the offense or the offender, and therefore it has nothing to do with the sentencing hearing. It's irrelevant. Put it aside. Never mind Section 24(1). It's not going to enter into the sentencing proceedings at all. So put that scenario aside. The second scenario is you've got evidence of state misconduct, police officer misconduct, for example. It does relate, have something to do with, be relevant to the circumstances of the offense or the offender. The sentencing judge can certainly take it into account in assessing all of the relevant evidence and facts in crafting a fit sentence without having to go to Section 24(1). And without having to get into, does this state misconduct amount to a charter breach? Then the court said, what we're really talking about, though, here is a case of an exceptional case involving egregious state misconduct in relation to the offense or the offender. And said in those circumstances, yes, it may be an appropriate remedy under Section 24(1) to ask the trial judge to give a sentence that falls outside the statutory limits, meaning falls below the statutory minimum provided in the code. So the court says, yes, there is that power, there is this remedy under Section 24(1), but then what do? They don't grant it on the facts of Nazagolowak. And the facts in Nazagolowak were that the accused, who was suspected of driving while impaired, was stopped by the police. He puts up some resistance. He's punched repeatedly by the police officers when he gives that resistance. He's taken to the police station. He doesn't get immediate medical attention. When he ultimately does start to complain that he can't breathe, he's taken to hospital. It's found that he has broken ribs, one of which has punctured his lung and caused it to collapse. He pleads guilty. I guess maybe Frank or John Struthers weren't representing him, because he ends up pleading guilty to impaired driving and flight from the police, and argues that his sentence should be reduced because his charter rights had been breached by the excessive force used by the police when they arrested him. The trial judge found that the police conduct did violate the charter, both Section 7 and 11D, and the remedy that the trial judge gave was under 24(1) to reduce the sentence below the statutory minimum of a fine for the impaired driving, and to give a conditional discharge for both offenses, the impaired and the flight from the police. The Crown appeals. The Alberta Court of Appeal agrees, yes, the police conduct did breach Section 7. It was fine to grant a reduced sentence as a remedy under Section 24(1), but says you can't grant a reduced sentence that falls below a statutory minimum in the code. So, Judge, you can reduce the sentence you would otherwise give, but you can't reduce it below the minimum provided for in the code. And so said in this case, it was an unlawful interference with the role of Parliament for the trial judge to have substituted for the minimum fine on impaired driving a conditional discharge. The Supreme Court of Canada agreed with the Alberta Court of Appeal. So, at the end of the day, I say to you, if on these facts, this accused couldn't get a reduction below the statutory minimum, what sort of facts is it going to take? And the only thing I can think is that perhaps if the accused had received an unfortunate but gratuitous beating by the police and hadn't offered up any resistance to the attempt to arrest him, maybe that would have resulted in that kind of reduction of sentence. But again, unfortunately, I think what the Supreme Court of Canada is saying, yes, the power is there, but is signaling to trial judges it's going to be a rare case where you will reduce a sentence below the statutory minimum because of a charter breach by the police conduct.
Habeas corpus. As anyone who practices mental health law knows, that remedy is alive and well and still very useful. It's the only remedy apart from exclusion of evidence that's expressly mentioned in the charter. It's not just for getting people out of jail. Habeas corpus allows courts to rule on the lawfulness of any aspect of detention. If there's something wrong with the way your client is being treated in custody or secure facility, habeas corpus is the way you want to go. Examples. One of my favorite examples is what some of the judges have been doing in some of the courts, which is have been directing the authorities to move offenders out of correctional lockups and into hospitals after there's a determination that the person is in crisis level need of mental health services. You couldn't get a more textbook example of the use of habeas corpus in conjunction with the charter. You got a Section 7 security of the person interest, you got a liberty interest, you got the right judge in Superior Court, you got all the ingredients there, you got an obstinate institution, you got money being the only reason they don't want to do it. It's the perfect recipe for creative counsel to do something proper for their client. And you've got a receptive audience. The Superior Court knows exactly what's wrong with the way mentally disordered people are treated. So that's one of my favorite examples. Of course, there are examples of expedited parole hearings that people like Mike Mandelkorn would be familiar with, or transfer decisions by prison officials, gratuitous transfer decisions, which are relevant to people who want to keep their clients in one place or another for what can be legitimate reasons. But habeas corpus is underused by the bar. At the moment, I'm not sure why. We used to use it, if you look in the case law, we used to use it like 25 years ago, quite a bit more than we do now. I'm not sure why it's fallen into disuse. It may be as simple a fact as Legal Aid Ontario doesn't fund habeas corpus applications any longer. Why? Because there's no risk of someone going to jail? Is that it? So you'd have to ask them. Anyway, no, they might have some other reason on their checklist. I'm just kidding. So that's it, I think, of the substantive things. I did want to ask Justice Fuerst, though, about practice tips. And you got the idea from the cases we reviewed that whatever trial judges might think about 24-1 remedies as they're listening to the story unfold about how the police or the investigators are behaving in a given case, the appellate courts have been very dainty about the power. So what is it trial judges want to see from defense counsel on that voir dire before they're going to step out and use the power at risk of being appealed or told, you should not have done that, Justice Fuerst. You're out there. It's too exotic what you're doing.
All right, well, bear in mind, as Frank has mentioned, you have to have an evidentiary foundation for your application. That doesn't mean that you always have to call viva voce evidence. Assuming there's no credibility issue, there are alternatives. An agreed statement of facts can be useful for all or part of the facts on the application. You may be able to use transcripts from a preliminary hearing in which the police officers testified about what they did or didn't do, for example. You may be able to use affidavits, bearing in mind the Crown's right to cross-examine the affiants. Obviously, the Crown's position on all of this will be important, but there is no reason why you can't, on these applications, work cooperatively with the Crown and try to streamline the amount and nature of the evidence you're going to produce. Limit the viva voce evidence. At the same token, in terms of written evidence, don't just pile in volumes and volumes of paper and expect the trial judge to read it. I've seen instances where counsel have gone on the internet and pulled stuff off the internet and put that in front of a judge on an application. We're not talking about that when we talk about streamlining. Limit the viva voce evidence, use written materials to the extent you can, work with the Crown to try to get agreement that you can do that. Be prepared for the fact you're going to have to prepare a factum and a brief of relevant case law. And again, to emphasize what Frank has said in a slightly different context, the days are long gone when criminal lawyers can say, I don't do paper. You do paper on these applications. It's important. Your factum is going to form an important part of the application. And furthermore, if you haven't put forward certain information or arguments before the trial judge, when you get to the appellate court, you might find that you're shut down. So spend some time on it. And the second thing I just want to emphasize is also bear in mind the timing of the application. Think, is this an application that needs to be heard before the trial proper begins, or is it one that can be more sensibly argued and presented once at least the Crown's case on the trial proper is in, or for that matter, all of the evidence on the trial proper is in? And if it's one that needs to be heard before any evidence begins on the trial proper, consider whether it has to be heard by the judge who will necessarily be the trial judge, or is it one of these kinds of applications that can be bifurcated under the new legislation and heard by a judge who will not be the trial judge.
We're good? Any questions before we wrap? We're good?
I want to thank Justice Fuerst and Frank Addario. It was an excellent panel.